Could the right to bear arms be infringing on the right to safety in public spaces? A complex question indeed, and one that's been at the heart of a recent controversy in California. A new California gun law, Senate Bill 2, was signed into effect by Governor Gavin Newsom. This law banned the concealed carry of firearms in sensitive places, including places of worship, public libraries, amusement parks, zoos, and sporting events. Newsom cited a spate of shootings across the country that left at least 104 people dead over a 72-hour period prior to the signing as justification for this law. But not long after, the law was temporarily halted by District Judge Cormac Carney, who issued an injunction deeming the gun control measure unconstitutional and repugnant to the Second Amendment. Carney's ruling was then put on hold by a three-judge panel that determined more time was needed by the court to consider arguments from both sides. However, this pause was then dissolved by a Ninth Circuit panel, effectively reinstituting Carney's original blocking of the law. They indicated that arguments in the case will be considered in April. Judge Carney, in his original order temporarily blocking the new state law, cited a recent landmark Supreme Court decision, New York State Rifle and Pistol Association v. Bruin. This decision changed the framework judges must use to review gun regulations, determining that modern-day laws restricting gun ownership are only constitutional if they're consistent with the nation's historical tradition. Carney indicated that California had not provided a sufficient historical analog to similar laws banning weapons in areas like zoos, museums, libraries, and hospitals. Thus, the law was effectively abolishing the Second Amendment rights of law-abiding citizens to be armed and defend themselves in public. California Attorney General Rob Bonta argued in response that Senate Bill 2 does indeed adhere to the guidelines set by the Supreme Court in Bruin. He expressed concerns that if Carney's decision was allowed to stand, it would endanger communities by allowing guns in places where families and children gather. In summary, the story of the new California gun law and its blockage is a tale of constitutional rights, public safety, and the interpretation of historical tradition. It's a delicate balance between the Second Amendment right to bear arms and the right of individuals to feel safe in public spaces. The debate is far from over as the Ninth Circuit panel plans to consider arguments in the case in April. It remains to be seen how this complex issue will ultimately be resolved.